Hey out there, legal warriors. Reckless endangerment. What is it, and why do I think it's one of the most overcharged cases in Washington State? If you're interested in the criminal law, stay tuned because this is the video for you. My name is Attorney Lance Fryrear, and I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 20 years. And I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people will get the help they need. Now just jumping right into it. Reckless endangerment. Why does that charge upset me? Right? Why, as a defense attorney and a former prosecutor, do I just think that charge is overreaching? Well, it's because of the definition. Reckless endangerment is defined as conduct not constituting drive-by shooting that creates a substantial risk of serious bodily injury or death. Well, how many things actually create a substantial risk of serious bodily injury? We're talking maiming, broken arms, stuff like that, or death, okay? And that's a gross misdemeanor, a non-felony charge. So you make a substantial risk someone dies, and it's a gross misdemeanor, which means police officers have the ability, at least at the city level, to write their own ticket for that right into court. And it really, pisses me off when I see that charge used in a lot of situations, okay? Because it's just the what-if type thinking. It really shouldn't turn someone into a major criminal, in my opinion. Okay, so what am I talking about? Well, what's a common area of reckless endangerment? Well, you're driving too fast, right? You're driving too fast. You're going 90 and a 60, and instead of getting the speeding ticket, you had a passenger, and we committed, we offended the police officer in some way, or the police officer's having a bad day. And I love police officers because I used to work with them, but this is still something I see, okay? And they write up, instead of speeding, they write up reckless endangerment. You could have killed someone. A gross misdemeanor charge in the court, and that is laughable, right? It is laughable that, in my opinion, that type of behavior, some, speeding, although be it bad speeding with someone in the car, is a substantial risk of serious bodily injury or death. How many things have to happen for that to be a substantial risk, right? Is everybody on the road who is speeding with a passenger guilty of a gross misdemeanor crime and can go to jail for a year, right? I mean, come on. So that's one area where we see a reckless endangerment charge that doesn't make a lot of sense. I've seen other areas that are a little bit, more out there. Hey, I left a child in a car, right? And maybe it was unattended, and so something bad could have happened, right? And there's separate charges for that, and we don't want to do that, right? I'm not saying that's ever something we want to condone or do, but is that really a substantial risk of serious bodily injury or death? I mean, it's just too much what-if thinking, right? There's other charges, leaving a child unattended in a car, things like that. So there's all these situations that could come up where just because someone is mad at the time, the law enforcement authority, they go to this catch-all charge, reckless endangerment. So getting off my soapbox, how do we defend that? What if we're facing that situation? What should you do? Well, the first thing you should do is not panic, because again, that's a hard charge to prove. Okay, so what you want to do is, take a look and see if you have a court date. If not, you might have one in the future. Get yourself in contact with an attorney, and then us attorneys can try to help defend the matter, right? How we're going to defend it? How are we going to defend it, right? Well, we're going to say, come on, pepper spraying, I've seen this case, right? Pepper spraying an animal to get the animal away from me. The animal comes in and has fumes on them, and a child now has, hurt eyes. And some officer charged that type of case as reckless endangerment. Well, the facts in cases, it needs to be foreseeable. It needs to actually be a substantial risk of an actual substantial bodily injury or death, not some what-if nightmare scenario that we might see in a movie, okay? And so oftentimes just the threat of common sense is going to make the prosecutor realize that perhaps this case was overcharged. Now, we might be in the wrong. We might have done some stuff wrong, but maybe not that much wrong. So maybe we need to do some classes, right? Maybe we need to take an aggressive driving class to show that we're not going to be so foolish as to put ourselves in that situation and endanger the public in some way, okay? Maybe if we, hurt somebody, if we got into a fight and we got charged with reckless endangerment, well, maybe we can do an anger management class. Maybe we can do some therapy or some counseling or a parenting class if our kids are involved, right? So there's things that we can do to make it easier for the prosecutor to see the weaknesses in their case, right? And I say this a lot, it is not the prosecutor's job to let you go. And it's not necessarily the prosecutor's job to convict you. The way I want to think about it is it's the prosecutor's job to respond to the case in some way. And the more things that we do as the suspect or the defendant to respond to the case, the more the prosecutor can ego can go, hey, there's been a response to this case. Well, now I'm more able to listen to what the defense attorney has to say. I'm more able to listen to the other side of the story, right? Because people make decisions. It's not about pure guilt or pure innocence or computer logic for those of us in the tech industry who work in a logical and think that type of way. Using computer logic will get you convicted every time, okay? So, but doing some things will make it more likely that your attorney can try to get the prosecutor to let you go. So, final tip, just, don't give up. Okay, don't go in and plead guilty. Don't just think it's going to go away either. Try to keep a level head. Get yourself some support, either through friends, family, or hopefully an attorney. And usually, a reckless endangerment charge is not going to turn into a reckless endangerment conviction because it's so broad, it's so overcharged, and there's lots of things we can do to try to make sure you don't get convicted of it. And if you do suffer a conviction, there's no mandatory jail, but it's up to a year max. It's something we want to avoid. So I hope you found this useful. If so, please like, please subscribe, and more importantly, if you're in this type of problem, feel free to reach out to my firm. We've been defending this type of charge for more than 20 years. We'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.